Mr. Gilbert, you're on mute.
Well, we know who the oldest guy in the room is now.
I don't know about that.
Well, I think I'm safe in that assumption. May it please the court, I'd like to reserve 5 minutes.
Okay, thank you.
Your Honors, in this case, the court below denied G4S's motion for a final summary judgment with respect to immunity, and instead found that we were entitled only to the cap on damages under 768.28. Need to just make clear in paragraph 25 of the motion for summary judgment, which is the last paragraph before the incorporated memorandum of law in the motion for summary judgment, we plainly said, based upon the degree of control PCSO exercised over G4S, defendant is an agent of the state and in accordance with Florida law is entitled to sovereign immunity. And that's the appendix page 17. And on page 18 of the appendix, we cite specifically to the language in 768.289A. No officer, employee, or agent of the state or any of its subdivisions shall be held personally liable in tort.
So some of the substance of your argument is your client is entitled to complete immunity and the correct party is the Pinellas County Sheriff's Office.
It's correct, Your Honor. Although I do find it interesting to try to dive into the difference between the level, or is there a difference in the level of control by the state entity, in this case, the sheriff, that results in a distinction between just the sovereign immunity cap applying or immunity applying? The answer to that, I think, is plainly no. In all of the reported cases where one form of relief or the other was granted, the consideration with respect to the degree of control is essentially the same. So it seems to me the deciding factor as to why we would be immune rather than just benefit from the cap is that we are not a state agency and not an instrumentality of the state. And what would be left if we are neither of those is that we are an agent, as the court in Morrow found.
Right. So let's talk about Morrow for a second, because you're right. You are right. In Morrow, we use the term agent, but if I read that case correctly, we ultimately determined that G4S's liability was to be found in subsection 5 of the statute. So yes, you are correct that we use the term agent, but we held, for lack of a better term, the limited liability would apply. Why is this case or contract in any appreciable way different than Morrow, such that the same result should not pertain here, that the form of liability is under sub 5, not sub 9, which you are now claiming?
The critical difference is actually found in the Morrow case. In the appendix, Your Honors will find that G4S did not plead for immunity under subsection 9A. They only pled for application of the statutory cap on damages. So the second district was not confronted in the Morrow case.
How do we know that from the, listen, I get this sometimes where folks will want to bring in things from past cases and say, well, look at the briefs that were filed in that past case, or look at the issues. But what we're supposed to do is just, the opinions are supposed to guide the lawyers, the litigants, and us. Whatever's in the opinion is in the opinion. The opinion says that G4S, under a contract that I am informed at least is not appreciably different than the one that is at issue here, that G4S is indeed although we use the term agent, is subject to, it gets sovereign immunity under sub 5, not sub 9.
Luckily, the second district opinion in Morrow was quite detailed, the analysis quite thorough. And you will not find in any page of the decision a reference to or an analysis of the issue of immunity versus benefiting from the cap. The only issue addressed by the court in its analysis, or I should say issues, was whether or not the degree of control exercised by the sheriff was sufficient to trigger 768.28. And then the court found that it was, gave all of the reasons why, and then its conclusion. Morrow is not a case that can be cited for denying immunity, as we request in this case, because that was not an issue analyzed by the court.
But it wouldn't be a denial. It would simply be just that your immunity would fall under a different subsection of the statute, right? Because that's what we're talking about. I don't hear the other side is claiming that G4S is entitled to no form of immunity whatsoever. The question here is which subsection of immunity do you all have?
Well,
And
plainly,
Morrow held it was sub 5. Now you're telling us no, it's sub 9.
so plainly, the appellee acknowledges that the sheriff exercised sufficient control so as to trigger protection under 768.28. The only dispute between the parties appears to be whether or not the nature of the agency relationship between G4S and the Pinellas County Sheriff is one that renders G4S as an instrumentality of the state. And the cases that find instrumentality have a consistent component. And that component is that the entity seeking the protection of the statute exists solely for the purpose of serving that state entity. If you look at Keck, which is the case that involved the Jacksonville Transit Authority, that's a case where the entity seeking limited, not limited immunity, but complete immunity was in fact an instrumentality of the state because they served a single purpose. This is really consistent throughout the decisions. You'll find that in the Plank case we've cited as well. By contrast, G4S is a large national company. It provides security services in a variety of environments, banks, gated community entrance gates. They do business in, I believe, all 48 contiguous states. They're part of a public company. They're not owned by a state agency. They weren't created by the state to serve as an adjunct to a state agency. Frankly, all of the qualities and characteristics of an agent exists, an agency relationship exists, as identified in the Morrow Court. That court wasn't asked to test whether 9A applied. The only relief sought was under 5. In this case, and by the way, Judge, to be candid, it's the same contract. It's not a substantially similar contract.
Well, and that kind of, that all that does, counsel, is just puts a glaring spotlight on the problem. And I'll just come out and say it. For us to write a reversal here, we would have to hold that, in fact, G4S is an agent under subsection 9, right?
Yes, sir.
And we would have a prior decision published that says G4S is entitled to sovereign immunity under subsection 5. We would have 2 opinions holding that under what you just said was the exact same contract, that there are 2 different forms of immunity, and it's subject to both, and that can't happen, right? I mean, you either you are an agency or you're an agent. You can't be both. To write the reversal that we would do to grant you relief, we would be holding, yeah, it turns out G4S is both an agency and an agent. How do we get around that? How would you write the opinion such that it would be consistent with Morrow's conclusion that that G4S was entitled to sub 5 immunity?
This is not a unique moment. Not the first time something like this has arisen. I would write the opinion to state that the issue of immunity under 9A was not addressed in the Morrow decision, and that issue was developed more fully in the record on this appeal, and that you're not admitting to an error in Morrow. You're simply pointing out that the issue presented in Morrow was quite different. The relief sought was quite different than the relief sought before this court, or I should say before the trial court.
Well, did we err in Morrow?
The
Well,
irony
you
is-
just suggested we wouldn't have to admit to an error, which actually we're very good at, but we have no problem. We make a mistake. We're the first ones to tell everybody. We receive from our cases all the time. So, but the question is, did we make a mistake in Morrow?
Well, it seems to me, in all candor, the mistake wasn't the courts. The mistake was the appellant in that case seeking relief under subsection 5 and not explaining to the court why 9A applied. And I would be less than candid if I don't tell you that I'm frustrated and concerned about the mistake that was made. It does little good to say that it wasn't made, but there's a problem. The
Well,
issue.
my question is probably going to add to your frustration, because I cannot escape the conclusion that subsection 2 defines your client. A corporation primarily acting as an instrumentality or agency of the state. This is the executive. This is the sheriff's office. They're constitutionally responsible for prisoners, inmates, arrestees. They're responsible for transporting it. They delegated that duty to your huge corporation. So I was trying to figure out why you were arguing about a huge corporation, because you're fitting right into this pigeonhole of subsection 2. Because if you read 9A, just the plain language, I don't need to go to the intent of anybody. An officer, you're not that. An employee, you're not that. An agent, singular. And then it says, shall not be held personally liable or as a party defendant, singular. You've got a huge corporation here. You don't fit in 9A. You fit in 2, and you get limited liability. And that's the risk that your client took. Your client knows that you're subject to the caps. You can't sit here and argue that you are an employee of the Pinellas County Sheriff's Office and that you're at their beck and call and you do everything they tell you to do, and at the same time tell me how big your corporation is and what else you do. You got to pick one.
Well, I am picking one.
Well, speaking of mistakes,
I'm sorry, Your Honor.
and following Judge Sleet's, question or statement, did you make a mistake in not pleading in any way that you're looking for total sovereign immunity? Because the first time it ever came up was in a hearing on this issue, but it was never pled in any way. No affirmative defense, nothing. It was never mentioned.
We did not plead under a specific subsection of the statute. We just pled generally for under limited sovereign immunity. And frankly, Judge, general references to 768.28 are typically referred to as the granting of limited sovereign immunity in general. When you get to subsection 9, that addresses immunity. But to answer Judge Sleet's question, I'm sorry that I didn't get to before, the Supreme Court of Florida has in several important occasions found an entire company as compared to an individual to be immune under 9A. And one example is Bean versus University of Miami. That's a third DCA case. The other is Stoll versus Noel in our Florida Supreme Court, where CMS, in effect, is an entire organization that's found to be immune. I think Your Honors look to who the contract is with. The contract is not with an individual employee who's seeking immunity. The contract is with G4S. And under the scope of that contract, the level of control plainly exists to establish that the sovereign immunity statute applies. Here's all that's left. Primarily, that's the key word, primarily an agent of the state. And in all of the instances that I could see, where it was a cap rather than total immunity was because the entity was created solely for the purpose of carrying out this state function. Not just Prison Rehabilitative Industries versus Betterson, where in fact the corporation was created to conduct the state's rehabilitation of prisoners.
You're at
based on-
15, just so you know. Use
I
your
may
time. as
borrow
you want.
just a few more seconds if I could, right? So the idea here is it can be an entire company rather than just an individual. And the significance of the scope of G4S and its activities is that it makes it impossible to find that they are, quote, primarily involved in providing a service to the sheriff. It's the scope of the company, not the scope of the contract. Thank you, judges.
Okay. You'll have 4.5 when you get back. Okay.
Thank you, Your Honor.
Thank you. Yes, sir.
Good morning. May it please the court. Troy Iannucci here for both appellees. I just want to clarify something that perhaps Mr. Gilbert has overlooked and perhaps this court did not actually notice in the public record. The Morrow case, their very first affirmative defense by G4S in the Morrow case filed on May 23rd of 2014 was that G4S was immune from suit under 768.28 subsection 9 sub A. It was an affirmative defense. Not only that, but when they moved for summary judgment, which this court of course dealt with on appeal, on January 14th of 2015, G4S Secure Solutions and Andrei Izrailov's motion for final summary judgment, what did it request? It actually called them an agent, and they requested
Mr.
summary
Iannucci,
judgment. Yes,
we can't go parsing through the record of past opinions in
Understood.
order to offer clarifying language. We got to work with what we put out there. We're stuck with our work product. So help me out here. We said in Morrow, G4S is an agent. Was that incorrect?
well, unfortunately, what this court did was that used the term agent. It also used the term state agency. It also used the term agency status, and it also used the term agency relationship.
Yeah.
When we compare that, because this court said that the contract was analogous to the Better Prisons or the Pride, the prison rehab case, they used the term agency relationship. They used the term state agency because they were talking about this corporation, which was a private corporation, primarily acting as an instrumentality of the state. They also use the term agency of the state.
Because they're talking about sub 5, and that's the language sub
Correct.
5 actually uses.
Correct. And I think that unfortunately there's been a commingling of the term agency and agent, or agents, even plural at times, and that has caused some confusion. Of the cases that were cited by Mr. Gilbert, of course, I actually think that the Bean and the Stolen in Prison Rehab case are interesting because Bean case dealt with individual physicians. And in that case, the difference was the Florida Department of Health and Rehab Services admitted full financial responsibility for what the individual physicians were doing. And they looked at the particular employment contract there, and a manual created what they called an agency relationship. But then again, that term agency, that applies, and that applies in both Morrow and the Pride or Better Prisons case. The Stoll case is really not analogous to what we're dealing with here because that case dealt with a specific statute that dealt with that party and granted immunity. We don't have a specific statute as to companies which provide prison transport. And of course, we know that in prison rehab or Pride, the corporation was deemed an acting as an agency of the state based on all the control that it had, which of course this court some years ago in the Morrow case said was basically analogous under this contract. So you've got all this control stating, hey, this corporation is under such control, it's acting as an instrumentality of the state.
So you believe
So-
the record evidence here establishes as a matter of law that G4S is a mere instrumentality of the state and is a state agency for purposes of sub 5?
Under that definition, I believe that would be correct, because the analogy used in Morrow by this court some years ago, of course, went into great detail about all the contractual agreements and requirements. And the court didn't just do that, but it specifically was talking about subsection 5 and the recovery limit of 200,000 for claims by one person and 300 per incident. And of course, it went beyond that, as Your Honor may have already mentioned, when it says under section 768.285, the sheriff and its agents, whatever that was to mean, are only entitled to limited sovereign immunity and may be required to pay up to $200,000 for claims by one person and 300 per incident or occurrence. That can't happen if you're not a party to the lawsuit. You can't be required to pay money. So I think that this court some years ago in Morrow just threw in the word agents accidentally, because it really talks about the Better Prisons case, which was a corporation acting as an instrumentality and only had the limitation of a damages cap rather than a full and complete and total immunity. So to that point, Judge, I think that particular word is basically left in there like a hanging chad.
Oh, yeah.
Let's don't have any more of those.
Do you agree? Do you agree with your friend on the other side that the contract at issue here is indeed identical to the one that was at issue in Morrow?
Yes, we know that, Judge, and we didn't dispute that in the trial court. All the filings in the motion for summary judgment in our particular case were actually affidavits and deposition transcripts that had occurred elsewhere. We could have objected to them and gone through the rigmarole of having all those affidavits and deposition transcripts, I should say. In our case, they were technically hearsay for the most part because it was almost all depositions. We didn't want that, though, because we knew we would wind up with the same result. We had the contract and we saw the date of the contract, and it was, of course, prior to the date of this particular incident. So we knew that was the controlling contract.
Got it.
That wasn't a problem. Obviously, in some of the brief, in which I think has already been mentioned, Judge, and I think it was you who talked about the liability was found in Morrow under sub 5. And once again, we could basically harp on that till the cows come home. But part of the problem that I think that Mr. Gilbert has is that he wants to be in a better position than the sheriff's office. They want to argue in their, that they can't be sued at all, and they're not entitled to any cap on damages. That is, they're not subject to them, and you have to go to the sheriff's office when all the facts that they filed in the lower court show that the sheriff's office, they're basically its instrumentality, and they're doing all the work of the sheriff's office. In fact, that the documents filed with the lower court show that this particular contract was for, just so we understand, was not just for transportation of prisoners. That's the subset that occurred with my particular clients. They had an agreement for stable, reliable, armed and unarmed security services through the Pinellas Juvenile Assessment Center, the Detention and Corrections Bureau, the Detention and Corrections Bureau in Clearwater.
So that shows that it shows that there's a big contract with the sheriff. But what about counsel's point that, yeah, but that's not all G4S is. It does work besides just the sheriff. It wasn't just set up to be an instrumentality of the sheriff's office or an agency of the sheriff's office. That there's a big private company that does lots of contracts with lots of people.
They might.
I mean, any more than you could say Lockheed Martin is an agency of the United States government, right?
Right. But if they act that way, that is, if all the duties you would normally have as a deputy for a sheriff's office is given sideways under contract, and basically you do, and you're acting as their arm, you're not an individual agent in the sense that you're some sort of representative, not under their control, because many cases talk about an agent, there's no physical control over what that person does physically. They just have some sort of contractual purchasing and financial things. There is physical control over what these particular, what would normally be a deputy sheriff for Pinellas County, what they have to do. They are armed, they are trained, they are provided shotguns, the all sorts of equipment. They are provided the vehicle. They are acting as though they are a deputy sheriff for more than just transportation. They're at the magnetic sections. They're providing security at the Detention and Corrections Bureau transportation section. The Clearwater Courthouse, G4S is there. So I think what we have is far closer to what Pride was doing. Pride was acting as though they were, Florida Department of Corrections, what we would normally call deputies, just as though G4S here was acting as a sheriff's office deputy. And because they're taking on all those duties and all those responsibilities and under such control that it's analogous to the other cases where they talk about being under such control that you have to see it as a corporation acting primarily as an agency of the state for all these purposes. And this is just our location, of course, Judge. We didn't get into all the other G4S contracts that deal with all the other sheriffs and all the other particular departments of law enforcement in the state of Florida. This is just the Pinellas County Sheriff's control over them. We didn't, there are various things that were not argued. Of course, I'm not even going to get to them. Certain things such as the driver of the bus, of course, which is in their brief, but the dismissal of the prior claim against the driver, Sharon Kresh, I can tell you that the reason that happened is more analogous to dismissing a sheriff deputy, because you can't sue the sheriff's deputy individually. You would have to sue the person's employer. So that has no bearing on this particular appeal. And of course, we know that to the extent that Keck was cited by the appellant, that was an employee, and that was actually a driver of a bus, kind of analogous to the driver of the prison transport vehicle here. And in Keck, it was found that the corporation was acting as an agency of the state. The driver of the bus was given complete immunity as an employee or agent, but the corporation was deemed primarily acting as an agency of the state. So that's the analogy there, very much like the Keck case. I don't believe we could have miscretion, even though I believe that G4S is the proper party, Your Honor. To the extent that it was an issue whether the appellant pleaded total sovereign immunity in this particular case, which is much different than the other case in Morrow, where they did, and the public record would instantly reveal that. In this particular case, it was only mentioned in a very paragraph and basically argued at the hearing for the first time. And it was mentioned in a wherefore clause, I believe. It was never pleaded as an affirmative defense. We know that because the appellant, after the appeal was filed and the briefs were done, sometime this year, the appellant actually filed a motion for leave to amend the answer in affirmative defenses in this case. Now they have an affirmative defense under sub 9. They did not at the time. I don't want this court to punt the ball back and say, well, the judge is right because it wasn't pleaded properly. The judge in this particular case obviously granted, or I should say denied for various portions, on September of 19, the particular motion for summary judgment, to the extent that the appellant here seeks complete immunity. And Judge Sharpberg specifically went and talked about that the appellant is entitled to limited sovereign immunity under subsection 5 and cites the Morrow case. Since the judge dealt with the issue of complete immunity, I don't think the court should even consider affirming just because of the pleading problems that we've argued in our brief, and I think might be seen by this court that occurred by G4S in the underlying trial court case. I would rather, since there was a final decision in September 23rd of 19, there was the order on the motion for summary judgment. It's obviously been dealt with, even if it wasn't pleaded properly. And obviously we want a resolution based on what Morrow cites and clearly cites, but for the term agents, I think Morrow determined that in essence, this corporation was so controlled, it was only entitled to the limited sovereign immunity under subsection 5 because of that, and not entitled to any sort of total or complete immunity. And as I say, the public record would reveal that that's what they actually pleaded and what they moved for in their motion, which was denied and wound up bringing them to appeal. And I think in this case, obviously, you can't be when this court stated in Morrow that the sheriff and its agents would be entitled to limited sovereign immunity and may be required to pay up to $200,000 per claim, you can't do that when you're not in the lawsuit. You can't be subject to that. So I think when you look at what this court has already done, I think it made more sense that they're not entitled to a complete and total immunity as an agent, but rather all the definitions of agencies and the degree or determinative factor being the degree of control retained by the particular sheriff's office over G4S shows that they were simply acting as an instrumentality of the sheriff's office, which being a county position or office is still, obviously the statute on sovereign immunity applies in terms of the limitation here. Judge, that's my time.
Okay. Thank you very much.
May I proceed, Judge?
Yes, please do.
In Bean versus University of Miami at 816, the court observed that Florida courts, state and federal, have extended Section 768(28) immunity to private companies and their employees. In Pagan versus Sarasota County Public Hospital Board at 884 South 2nd 257, the court wrote, in some circumstances, the analysis of whether a corporate entity is an instrumentality or agency focuses on the extent to which the corporate entity has been given the authority and responsibility to carry out a management function that would otherwise be directly carried out through governmental officials, citing to Skoblow, S-K-O-B-L-O-W, at 483 South 2nd, 809, at 811 and 812, holding the corporation under contract with state to provide direct management for state hospital and to coordinate long-range planning for the hospital was operating as an agency of the state.
I'm not so sure Bean gets you where you want to be, because Bean, the court already starts out by saying that the University of Miami Medical School has absolute immunity under 9A. And anybody they hire has immunity as an agent, officer, employee. So it's the nature of the entity. University of Miami is accredited medical school, which is defined in 982. So they're already starting out with complete immunity. Your company doesn't. They're not even listed in any of these enumerated definitions or any of the statutes that are referenced in there. So I don't think Bean gets you there. Miami is an accredited medical school, which is defined as an officer, agent, or employee under 9A. They already have the immunity. So anybody they hire has the same immunity they do.
They don't have the same immunity, Judge. It was found that they had complete immunity.
Well, so does the University of Miami under 9A. They have complete immunity.
So if Your Honor considers that there's not an issue before you, not a dispute before you, that the requisite degree of control exists to trigger the statute, the only question becomes, how do you distinguish between an agency and an agent? And the context here, the use of the phrase agency relationship only goes to describe the servant-master relationship between G4S and the sheriff. It doesn't go on to define that we are an instrumentality of the state. I don't believe Morrow can be used to support that finding. We're not an instrumentality of the state. And because we have no management function, and because the sheriff dictates all that we do and how we do it, where we do it and when, we're not susceptible to being an instrumentality of the state or a state agency. So I understand the 25-pound weight I'm carrying around in my back pocket because of the way relief was pled to the court in Morrow, and when I say the court, I mean the second DCA. But plainly, the issue was not addressed, analyzed, or resolved in the Morrow decision. We asked this court to analyze and resolve it as part of its decision in this case. Whatever the final decision of the court, it would be beneficial to make this clearer. Thank you, judges.
Thank you very much. Thank you both. Well argued, and we appreciate your efforts. Our next case is Kochman versus Sarasota County.